One of the biggest issues over the last year or so has been the issue of Article 8 and the new rules, and to what extent Article 8 is now encompassed within the rules. We've had judgments like Nagre and Gulshan, and most recently the Court of Appeal decision on the minimum income requirement, Now, there's been some controversy about whether there is a threshold requirement as to where Article 8 needs to be considered outside of the rules. The most recent judgment, and what I want to talk to you today about, is a case called Olodoyi and others. I've put the link in the notes on YouTube below this video, and it's an upper tribunal decision in a judicial review, and it's a decision by upper tribunal Judge Gill. And what Judge Gill says in this case is there is nothing in Nagre, Gulshan or Shahzad which imposes a threshold test for consideration of Article 8 outside of the rules. And she follows the approach set out in in paragraph 128, and the recent decision by Michael Fordham, Queen's Counsel, sitting as a Deputy Judge of the Queen's Bench Division, and I'll probably mispronounce it, it's Ganabasalan. And again, the link is in this judgment. That judgment of Michael Fordham is really helpful. It's worth citing in judicial review grounds, and it's also worth using in skeleton arguments before the tribunal. So she says they weren't imposing a further threshold test in Nagre and Shahzad. She was just considering whether there was anything that needed to be considered that wasn't already exhausted by the rules. So if you go to paragraph 19 of Judge Gill's judgment, she firstly gives some agreed principles. She says it's not in dispute that Section 6 of the Human Rights Act makes it unlawful for a public authority to act in a way that's incompatible with the Convention right. Well, that we all know that. Secondly, the judgment, she said of the Supreme Court, of course it was the House of Lords, in Hwang still applies. Well, that's good, because sometimes the old jurisprudence has been forgotten about. The Hwang test is still the correct test. She says this in point 3, Strasbourg and domestic jurisprudence in relation to Article 8 still applies. So cases like Chikwamba are still good law. She then says at point 4, there is nothing in Hwang or in domestic jurisprudence or Strasbourg jurisprudence which supports the proposition that a threshold must be reached before the obligation to consider Article 8 claim arises. Likewise, at point 5, there is nothing in the judgment of MF Nigeria which requires that a threshold is necessary before proportionality can be considered. So they were her agreed propositions. She then, at paragraph 20, summarises what is said in the head note, that where it talked about good arguable grounds in Nagre and Gulshan, this was not a threshold test. It was just considering whether there was anything that wasn't exhausted by the rules. Interestingly, at paragraph 23 of the judgment, she looks at, well, what do you consider when you look at the Razgar steps outside of the rules? And she says in some cases, a decision maker won't need to go through all the full 5 steps of Razgar, but can jump to proportionality, which is dealt with in questions 4 and 5. So it may be acceptable to look at the matters outside of the rules just in terms of proportionality. The judge then goes on to consider the substantive JR challenge in this case and dismisses the substantive challenge. So this is a helpful decision that practitioners should use to show that there is no threshold before Article 8 can be considered. There still will be those cases where they couldn't possibly succeed outside the rules. But what you must remember is those factors that don't come inside the rules mustn't be considered on their own. Article 8 must be looked at cumulatively. So a decision maker or a tribunal judge should step back and look at the whole of somebody's Article 8 rights. Paragraph 49 of Mr. Justice Sale's judgment in Nagre says that. Also, the judgment of Michael Fordham in Ganabasalan is really helpful in that respect. So I'd encourage you to use that and cite that. But this case is helpful in clarifying that there is no threshold imposed by Nagre and Gulshan, and endorsing what was said at paragraph 128 of the judgment of